Good afternoon, everybody. Thank you for coming. We've got quite a few people online, so we have to apologise to them because there was a bit of a mix-up with the start time. So they've been waiting since 3 p.m. patiently. So sorry and thank you. For those of you in the room, toilets back beyond the stairs, down the hallway. If there's a fire, there'll be an alarm. Apparently, we get ushered out, or if there's a fire there, we have to jump out there. And you all get rewarded with copious amounts of food and alcohol afterwards because a lot of people are online. So, sorry guys. And for those that are going to be watching this as a recording sometime over the Christmas break, surely there's something better on YouTube. Today's presentation is going to be about Section 22, effectively trying to unravel the tangled web of which it is. And to help you do that will be Chrissy, Psevdos, Special Counsel with KJK Legal for the past 6 months or so, but coming to us with 20 years experience in workers' comp. Recently recognised in Doyle's Guide as one of the best recommended legal practitioners in workers' comp in South Australia. And notably only receiving that since starting at KJK, of course, after many years in the shadow of much larger firms that obviously didn't allow her to shine. And our second speaker will be Tracey Kerrigan. Probably doesn't need any introduction. However, Tracey is sick today, so she's got to be doing it via Zoom from her bed. But look, she wears Uggies at work anyway, so nothing's new. Tracey has almost 40 years experience and was recently voted a preeminent lawyer in Doyle's Guide. So she's finally reached the pinnacle. And just by the way, KJK was also voted the first tier workers' comp firm. So we actually outshone the big guys like Mintus and Sparks. So little guys, punching above our weight, but hopefully we'll continue to do that with you guys because our client base certainly reflects the standard of work that we think we can offer you guys, and we appreciate your instructions. The topic today will be, as I said, Section 22, lump sum entitlements, how to calculate them. There's been a recent Supreme Court case, only hot off the press in the last week or so, that Chrissy will talk about. Amongst others, we'll be talking about the one assessment rule, how the principles apply to assessing Section 22 claims, what is MMI, stability, one of the more complex matters of combination of injuries and assessments, and then dealing with deductions for pre-existing impairments, prior Section 56 and 58 payments, Section 56A, and then at the end, Tracey will take you through essentially a case study from go to woe as to having a claim come in, going through the process, what happens right through to the court process, and finalisation by resolution of some form, whether it's judgment or settlement. So I will introduce, well, I've already introduced Chrissy, so I will call her up to the podium and we'll get started.
Oh, it's so tall. Okay. Designed to be a truncated version, if you keep that in mind, otherwise we would be here for a really long time this evening, but trying to draw out for you pragmatically the best processes to use as we go along from experience in terms of what we've seen in the dispute process down at the SAE as to things that crop up that are really hard to undo, if you like. So please interrupt me if you've got any questions as we go along. We'll make sure this is working. All right, so we will be looking at lump sum entitlements, 56, economic loss, 58, non-economic loss, and how to calculate them. The old one assessment rule, if you like, assessment principles, stability or maximum medical improvement, as we know it at MMI, combination issues, deduction issues. If I lose you at that point, please try stay awake. We'll get there. looking at pre-existing impairments, prior 56 payments, prior 58 payments by way of looking at overall deductions, and finally 56A. We're going to do that by looking at some of the case law as well, and then Tracey is going to take you through a practical guide by looking at a case study. Okay, so we all know that for a worker to claim lump sum compensation under Section 58, the non-economic loss component, and 56, economic loss, which only applies to injuries post 1 July 2015, an assessment must be made of the worker's whole person impairment. So the WPI, whole person impairment, and lump sum compensation, as we know, accrue for physical injuries, and psychiatric claims do not attract any compensation, but we know that we use the assessment for whole person impairment for psychiatric claims when we're trying to determine if someone is going to meet the seriously injured threshold, which still remains at 30% whole person for those claims. Psychological sequelae, or as the Act terms it, consequential mental harm, is ignored when assessing permanent impairment, but a primary psych injury is assessable under the IAGs and GEPIC for the purpose of determining if the worker who's suffering that psych injury is, as I said, seriously injured or not. Not entitled, however, to any monetary compensation under either 58 or 56 for the primary psych injury. The whole person impairment assessment is only relevant for the purposes of determining, again, whether they are going to be SI. Okay. Oops, I may have jumped ahead, sorry. There we go. So Section 22 sets out our requirements for assessing the degree of whole person impairment arising from that work injury or work injuries. The assessment must be in accordance with the impairment assessment guidelines. I'm going to refer to them as the IAGs, of course, and be carried out by an accredited assessor, the simple stuff. Before any assessment can be made, you must be satisfied that the injury or injuries have reached maximum medical improvement. In other words, the injury is not likely to change in any capacity in the foreseeable future, or is often referred to as being stable. If a worker is likely to have surgery in the near future or is having significant or intensive treatment, then it's likely MMI has not been reached. To clarify that issue, it might be necessary to obtain medical evidence from treating medical practitioner or other treatment team as to whether or not that injury has reached MMI or not. It might also be necessary to obtain evidence, including medical notes, as to whether a particular injury has in fact caused any impairment. It is unsafe to simply rely upon the worker's history to the assessor. Some objective evidence, notes, diagnostic results should be obtained to also be provided. And as you know, as part of the process, the nominated assessor does have to confirm before formally providing the assessment that the individual has reached maximum medical improvement. They are supposed to, in examples where they feel as though MMI has not been reached, not proceed with the examination. Okay, so the IAGs do not allow for more than one assessment, the one assessment rule. Therefore, it's important to provide the assessor with as much information as possible in advance of the assessment, as challenging the assessor's opinion post the assessment is quite difficult. In that situation, we know that Judge Gilchrist, in the matter of Abraham, noted that you can challenge an assessment, but it's not a free-for-all. There must be information that casts doubts on the factual basis of the assessment. That means the assessment is ultimately unreliable. If that occurs, the only option will be for the tribunal to refer the matter to an independent medical advisor. Right? That's our position. It should go off to an independent medical advisor for that assessment to be made. Of course, we know that the other side do request that the presiding member hear the evidence and substitute assessments, if you like. What's pleasing is that a lot of the cases are determined with the presiding member indicating that it should go off to an IMA if there's a finding that there has been a flaw in the report. All impairments from the same injury to be assessed together. Impairments from different injuries are to be assessed in chronological order and not combined. Until recently, can I just say? So bear in mind, that's a very general statement. Any pre-existing impairment must be deducted by the assessor, subject to the proviso that if an injury is an aggravation of a prior injury, and there has been a prior Section 43 or Section 58 payment, then there is no percentage deduction from the whole person impairment assessment. Claims specialists simply carry out a monetary deduction at the end of the day, deducting the prior payment from the current entitlement, and we'll look at the matter of a noddy as we move on. If the injury is a new injury, even if there is a prior payment for the same body part, the assessor must deduct the percentage impairment pursuant to clause 1.23 of the IAGs. So it's important to determine if an injury is a new injury or an aggravation of a prior condition which has already been compensated. Easier said than done, we appreciate that in some circumstances. Again, a lot of the time that requires that medical clarification, medical evidence. The worker is not entitled to any monetary compensation under either Section 58 or 56 for a primary psych injury. The whole person impairment, again, is only really relevant for the purposes of assessing whole person impairment, seriously injured status.
In that respect, and we're pre-arranged, I'm going to add a little comment as we go through, but in terms of pure psychiatric injuries, physical sequelae is an exception to that rule. In terms of things like bruxisms, a pretty standard sort of consequence of a primary psychiatric injury, or alternatively a consequential psychiatric injury to a physical injury, which that consequential psychiatric injury has physical consequences as well. So plenty of exceptions to the broad rule.
Indeed, and I would be misleading you if off the top of my head I tried to remember which presiding member it was, but the relevant decision in that regard is the Walker decision, if you wanted to have a look at that. As we know, until recently, there could only be that one assessment made of all impairments, so the one assessment rule, from all injuries arising from the same trauma and or cause. But recent amendments to the Return to Work Act allow for a worker to pursue a separate and later claim for whole person impairment, but only for an injury or impairment of which they weren't aware of at the time of the original assessment or that first assessment. For example, if a worker develops a gait disorder as a result of a lower back injury at a date after the original assessment, they may now still be able to pursue that claim. Surgery no longer constitutes a separate injury and is considered to be part of the original injury under subsection 6 of section 7. If a worker has an assessment of whole person impairment and their section 58 entitlement is determined and later they have surgery, then they would not be able to seek a further permanent impairment assessment, which constitutes a significant departure from our previous Act. Okay, so calculating the entitlements for Section 56 lump sum entitlements is somewhat technical and requires access to the prescribed sums publication, which is located on the Return to Work website. I'm sure you've all got the publication. Schedule 6 of the Return to Work Act, and payroll information. The payroll information that was probably used when you were determining the average weekly earnings calculation at the commencement of payments or weekly payments. And that's something that we really do think is very important in terms of having determined what that hours factor might be and have that recorded on the file, because depending on the overall percentage assessment, we do find in dispute situations that, of course, everyone is likely to have the argument that that percentage should be higher than ultimately what it might be. So prescribed sum for the relevant calendar year of injury is the start point in your schedule of sums. So again, you look at the percentage and that gives you the overall sum of monies. That's multiplied by the age factor. Again, important to note that it's the worker's age as at the date of the injury, not as at the date of the assessment. Multiplied that by the hours work factor, which is put in as a overall percentage. Lump sum compensation for under Section 58 for non-economic loss is far easier. So percentage and on the table with your year of injury, and that gives you the nominated sum for the relevant calendar year. Where it gets a little bit trickier, as you know, if we've got multiple assessments that require combination, the combined values chart in the AMA 5 is used to combine multiple impairments. And I've just given an example there so that if a worker makes a claim for left and right knee injuries sustained in the same incident, the worker is assessed as having 25% for the left knee, 12% for the right knee. The combined assessment is 34%. We don't follow basic maths. It's not 37. And again, it appears that basic maths go out the window after about 18% or so. That seems to be the magic figure, where 18 plus 1 is still 18 and not 19. So please double check with the chart. To combine or not combine is probably one of the most significant issues that we have to consider, and particularly when you're looking at those multiple injuries into one assessment, and is very much the most contentious issue, I think, in terms of disputes where it comes to these assessments. Critical issue, and also affects those injuries and impairments, whether they're a sequelae or not. And we're going to look at Summerfield, Preedy, now Williams, and also English, which will make that a little bit clearer, because the case law on this issue was split, as Neville indicated, until the week before last, where Williams and English were finally decided by the Supreme Court. So if we look at Mr. Preedy's case, he sustained a neck injury on the 16th of April 2013 whilst he was undergoing physiotherapy for a left shoulder injury, which was sustained on the 24th of August 2012. The neck injury did not result from the same trauma, and initially, at first instance, the judge decided that the two injuries could not be combined. However, the full bench of the SA disagreed with that view and allowed the two injuries to be combined for the purpose of determining whether Mr. Preedy was a seriously injured worker or not. The full bench took the view that for the purposes of an assessment under Section 22, the methodology for assessing whole person impairment in general, multiple impairments from the same injury or cause are to be assessed together or combined, but in connection with an assessment of non-economic loss under Section 58, they are to be combined if they arose out of the same trauma. That out of the same trauma became the most contentious small sentence that we could have ever imagined. So the matter proceeds to the full court of the Supreme Court, and essentially the court took the same approach. So as it stands presently, because the High Court was not it's not Mr. Summerfield, I'll go back a step. Any condition which is sequelae to the original injury, example, gastrointestinal issues caused by medication, a left knee injury which is caused by the altered gait from a primary back injury, etc., to the right knee, things like that are to be combined with the original injury. So the chain of causation seems not to have been split, if you like, or separated. That flowed on in terms of Mr. Preedy having been pre-2015 legislation to Mr. Summerfield, who fractured his left leg and hip in a fall. As a result of that injury, Mr. Summerfield had a hip replacement and developed a limp which caused him back pain. He later claimed for his lumbar injury and the claim was accepted. When the time came for Mr. Summerfield's entitlements to lump sum compensation to be calculated, Return to Work determined that Mr. Summerfield was entitled to lump sum compensation on the basis of 31% whole person impairment for the left leg and left hip and 8% for the lumbar spine. The issue, of course, in dispute was Return to Work SA's position to separate out those two assessments, to not combine them, because, of course, Mr. Summerfield was seriously injured. He was already at that 31% as a result of the left lower leg impairment, but it was a matter of principle insofar as alleging that the two injuries had not occurred from the same incident and or cause. The Supreme Court found that the lumbar spine impairment arose from the same cause as the impairments to the left leg and the hip. So the outcome of that case was that the assessments were to be combined, and the Supreme Court attempted to simplify, the definition of impairments from the same injury or cause by effectively looking at the chain of causation by reference to the old-time classic, the but-for test. So we weren't supposed to be looking at things as the but-for test, but they basically said that's the way to consider the chain of causation. It was appealed to the High Court. The High Court was not interested in terms of looking at the matter, because as I understood it at the time, despite Mr Summerfield's case having quite a significant impact to our scheme here in South Australia, it wasn't any larger impact than outside of the state. Okay, so, whoops, I think I've gone ahead. So following Preedy and Summerfield, we were still very much attempting to separate some injuries, for example, medication-induced type injuries, impairments that arose from repetitive work activities over a period of time. That scenario is looked at in the matter, of Williams, and the impairment from a fall due to the effects of medication taken for a work injury was examined in the matter of English. Mr English's matter grinds my gears a little bit, because it was little old me who indicated to return to work that this fact scenario had significant consequences in maximising people's lump sum entitlements if the worker succeeded. So off we went in terms of litigating and maintaining that medication-induced injuries should be in fact separated and not combined. Mr English's fact scenario was that he suffered a work injury to his neck in March 2019. There was nothing untoward about that. It was a genuine neck injury. There were no issues with respect to that at all. But he was taking Lyrica as a result of that neck injury. In May 2019, so he makes a very quick return to work, and he suffered a further work injury when he fell and injured his right quadriceps. The fall, he said, occurred as a result of the lightheadedness caused by the prescribed pain medication Lyrica that he was taking for the neck injury. Now, there was no question the medical evidence that we had at the time was very much consistent insofar as a very known side effect of Lyrica was lightheadedness, dizziness. So it wasn't that we were contesting that aspect of his evidence. We were simply saying that having made a return to work, the right quadriceps had no relationship whatsoever to the primary neck injury, and therefore the two assessments should be separated. Again, we weren't trying to be cheeky. Mr English, whether the assessments were combined or not, was not going to be a seriously injured worker, so it wasn't trying to deny him staying on the system long term at all. It was really just trying to get the answer to the fundamental question of whether these medication-induced injuries continue to be combined or not. Again, as I said, return to work chose not to combine the impairments, and we won't name the person who told them to do that, given the outcome. But the Court of Appeal in this case found that both impairments were found to have arisen from the same injury. So they were related to the neck injury and from the same cause, the event that caused the initial neck injury, or indeed the neck injury itself. So they were to be combined, despite the second impairment not being physiologically linked to the first impairment. The only real comfort I take out of the English judgment is the dissenting opinion of Chief Justice Caracas, who supported my views that under section 22(8)(c), when we look at combination, he was of the view that impairments have their origin in and progress from in the same sense of being etiologically linked to, and that makes it the same cause. So he didn't think that, in essence, medication-induced injuries should be combined, but he was the dissenting opinion. But that was essentially the foundation as to why ultimately we looked to challenge that. Mr English's case piggybacked what was already on appeal, which was Mr Williams' case, in an attempt to expedite the appeals process, because you'll recall that all of these matters had stagnated, of course, in the tribunal waiting for these judgments. Mr Williams worked as an electrician. From early 2015, he was required to do more physically demanding work, including having to climb up and down ladders and stairs and do more work in a crouched or kneeling position. Over time, Mr Williams suffered increasing pain in both knees, undergoing surgery to both of those knees. He made a claim for lump sum payments under section 58 of the Act, but the Return to Work Corporation chose not to combine his two injuries when determining his entitlements. The Court of Appeal found that section 22 wasn't just limited to subsequent injuries arising from the initial injury, but that it extended to the combination of impairments from multiple injuries that both arose from the same incident or event. In other words, both knee injuries were caused by the regular climbing and crouching that Mr Williams was required to perform between May and August of 2015. So that's quite significant. Is that it? Has the issue of combination of impairments been settled? I'm not so convinced, but what is evident is that the Court of Appeal thinks that this issue has now been settled insofar as it won't take too kindly to parties attempting to re-agitate the principles in these 4 cases. There are comments within the judgment effectively to indicate that it will have to be a very different fact scenario to try and distinguish these cases for them to have any interest at looking at this issue again. Sometimes those fact scenarios do exist. They require a little bit more thought behind the scenes, if you like. So we do encourage you all to seek advice if you think that your fact scenario is a little bit different. Again, particularly if the assessments are overall going to impact whether someone gets to 35% or not.
Does leap over into the deduction provisions and ignoring other causes, but it sort of dovetails into this as well. I can think of an example that might be the exception to the approach, and that is if you've got a left shoulder injury at work and then you're back at work and you're doing some work and you tend to overuse your right shoulder and you might develop symptoms in that regard. If that was all we had to deal with, that would fall within the parameters of these. But what if I tripped over and then shattered that other shoulder as well? Through no medication-induced lightheadedness, for example, there's potentially an exception to that notion of combination, but also tending to make sure the doctor ignores the effect of the fall in its injury as opposed to what might be the developing problem, say, with the rotator cuff because of overuse. So, a potentially extreme scenario, but I take it from a case that I had where that was the sort of thing that potentially developed. We settled the matter, but it was, perhaps one limited exception to this broader overarching rule.
Absolutely. So again, just really important to, it doesn't sound like it happens, but you do get that fact scenario. Again, sometimes not accepting on face value what it is that the injured worker is also reporting in these situations. So looking behind the fact scenario that you've got by the medical evidence or the clinical notes that you do collect as part of the investigation process leading up to the assessment. We'll now look at the impact of previous injuries to the same body parts, what entitlements flow from those, aggravations of previous injuries, etc. And the relevant clause in the IAGs, as you know, is clause 1.23, which provides for situations where prior impairment is disregarded or taken into account and therefore can reduce the current assessment. Alternatively, it provides for situations when you ignore such impairments from unrelated injuries and therefore disregard them. If a prior injury or pre-existing condition has caused an impairment to the same body part, which is to be assessed presently, then that prior impairment can be deducted from the current assessment and reduce the overall percentage allowed. Again, very important that the report request we're sending to the nominated assessor steps those things out quite clearly, because we know how excited the doctors are about making deductions. If you're not sure whether there's a prior impairment, then the assessor can be asked to identify such prior impairment and take that into account. To make that assessment, the assessor will normally need some evidence to show the extent of any prior impairment. In that regard, as you know, medical notes, prior x-rays, diagnostic results are all needed to be obtained in order to establish the extent of that prior impairment. In the absence of such notes or diagnostic results, it may be difficult for the assessor to deduct any prior impairment from the current percentage. That's the easy part. Unfortunately, even when we collect all of the evidence and there is enough material for a doctor to make an assessment, we are finding that the doctor reports back that for whatever reason, well, actually they don't even give you the reason, they just say they're not able to make that deduction. So that is an area of contention that we encourage you to take that point. If you are satisfied that there is enough material, and I completely appreciate that the AMA guides are not the easiest to follow, but it's pretty clear when a deduction should be made. It's very clear from the authorities that if that deduction is able to be made, the SAID is supporting that deduction to be made. So we have to sort of keep going back to the doctors and encouraging them to do it. Easier said than done, of course, and we will look at that in just a moment. That's difficult when you can't get the consent of the injured worker, particularly if they're not represented, to then go back to the doctor to address that, because we know that we can't unilaterally do that from other decisions that we will look at. We also need to identify if a worker's situation falls under clause 1.23 of the IAGs, or if clause 1.30 and section 58(7) are more relevant. If the current injury being assessed is an aggravation of a prior injury and there has been a previous payment under section 43 of the 86 Act or section 58 of this Act, then rather than deducting the percentage for the prior impairment from the current assessment, the assessor ignores the prior impairment and simply gives his percentage of the overall impairment. It is then our job to carry out the monetary deduction of the prior payment from the current monetary sum. It's therefore important to establish whether or not the condition now being suffered is an aggravation of a prior injury or is in fact a new injury. Just because a worker previously had a payment for a lower back injury does not mean that the current injury is an aggravation of that prior injury. I use the back as an example because whether you're looking at the cervical spine, the lumbar spine, the thoracic spine, of course, we completely appreciate the levels of the spine. So for example, C5, C6, but you also know that with some particular procedures to the spine, that the levels above and below are going to degenerate at a much faster rate. So arguably in the past, we have attempted to say that that's all part and parcel of one injury. We haven't been too successful in that regard, but we've certainly tried it. Again, it's an issue that we'd need to clarify with the treating doctor to determine whether you're dealing with a new injury or aggravation. Treating doctors will always come back and say, oh, it's a new injury. Important to perhaps get some independent evidence to say whether there's any consistency in that opinion or not, whether that's something you can challenge. That specifically leads us to Mr. Onotti's case. He was paid in 1996 $8,310.60 by way of non-economic loss lump sum under section 43 of the old Act, and that was on the basis of that being a 6% whole person impairment. In 2015, he claimed a further lump sum under 58, and he was then assessed as having 9% whole person impairment. Return to Work SA argued that for the purposes of determining the entitlement, 6% was to be deducted from the 9%, that left 3%, basic maths applied, and therefore he was under the 5% threshold, so he receives nil. This was challenged and went to the Supreme Court, and the full court indicated that the prior payment meant that the dollar amount should be deducted. So it was 9%, which equated to $18,756 for the 2015 prescribed sum, less the $8,310.60 he received previously. The balance was his entitlement. How then do we take into consideration the injured worker who's already received a lump sum for economic loss and suffers further injury or injuries by way of aggravations, etc., or those new injuries under 56(6)? We know that the Act provides that there will be a reduction of the lump sum payable in respect of the second entitlement by the amount of the payment for the earlier entitlement, unless such a reduction is incorporated into the provisions of the IAGs, and then this subsection will apply in relation to any third or subsequent entitlement in the same way in order to ensure that each lump sum previously paid is taken into account as new entitlements arise. What's a new injury? Turning our minds to whether or not something is a new injury or a subsequent injury, even to a different body part, again, that outcome was highlighted in the matter of Mr. Williams. Q, Ms. Jacurmis's matter, when we're talking about section 56(6) payments, she was injured in 2016. She sustained an injury to her right shoulder at work and was assessed as having a 17% whole person impairment. So she received a lump sum of $76,000. The year later, she injured her left shoulder at work in a new incident. She was assessed as having a 13% whole person impairment in relation to the left shoulder. 13% whole person impairment for her 56 entitlement purposes translated to a lump sum of $45,000. The court had to determine whether or not she then received that $45,000 or whether she received nil. That was, of course, taking the deduction of the $76,000 prior payment for the right shoulder. The full bench of the tribunal found in favour of Ms Jacurmis and awarded her $45,000. The full bench said that a new work injury is a further work injury where a portion of the impairment is due to a previous injury. The full bench held that the left shoulder injury bore no relationship to the previous injury and therefore no deduction was to be made. That didn't sit well with any respondent in the state, to the extent that also Return to Work SA intervened in the matter. It was Woolworths that was appealing the matter in the circumstances, noting, of course, the potential significant impacts to entitlements if you had to stop making that deduction in the fashion that we had been making it since the commencement of the Act. On appeal to the Supreme Court, they found that the phrase "a new work injury" carries a wider connotation of any new injury, and they therefore decided that Ms Jacurmis's entitlement for her left shoulder was nil. So order was restored, which was good, and everyone stopped panicking. That, in essence, covers some of the legal and technical issues that we deal with. We'll turn to very generally now looking at how it is that you prepare for a permanent impairment assessment, trying to take into consideration all of those difficulties. It's necessary to assess if the injury or injuries, as we said, have reached maximum medical improvement. As indicated, you may have to seek medical clarification from the treating GP or treating surgeon as to whether or not the MMI has been achieved. I'm not sure what everyone's internal policies are, but it is as simple as asking the question on a little yes/no checklist for the doctor. They seem to return that faster than requiring them to actually do a whole report for you. So it can be done very quickly and is generally the first point when someone puts their hand up and says, "We'd like to be assessed now." The permanent impairment assessor, as I indicated earlier, will also be asked the same question. If a worker has had surgery, it's always useful to have a post-surgery report from the treating doctor, surgery notes, photos, etc., if at all possible. We may want to investigate also which injury is the one causing any permanent impairment, particularly where you have a series of similar injuries dating back over a long period of time, perhaps only causing short periods off of work. A very simple muscular injury that, 1 or 2 days, some physiotherapy, and that's all we heard of it. So they're the particular examples of what I mean in that fact scenario. Obtaining an IME, commenting on which of the injury or injuries have caused permanent impairment, or even a comment from a treating doctor on that issue may be useful, especially if those injuries predate this Act, the 2014 Act, and for some that post-date it. This can be an impact on the entitlement of course, both the 56 payments, 56 and 58 payments, especially now when we have Williams and English, where predominantly our chances of now not combining have become quite difficult for us. It's important to consider whether which assessors are likely to be able to assess the conditions from which the worker suffers, and whether you need a lead assessor and secondary assessors. So again, the mastication deglutition injuries that we see versus your primary assessor who is going to do any of the orthopaedic type injuries, etc. We take the view that the lead assessor should be the assessor who is assessing the primary injury. The secondary assessors can then provide their report to the lead assessor, and the lead assessor then combines all of the reports and the assessments into one whole person impairment. Once you're satisfied, of course, that MMI has been achieved for all injuries, you must send the letter, of course, to the worker outlining those injuries to be assessed and indicating the accredited assessors for the relevant body parts. The worker is then, as you know, able to choose their assessor in consultation with us. Unfortunately, there hasn't been any judicial interpretation of the word consult, but there has been one case, that's the matter of Shord, where the worker endeavoured to force the compensating authority to use their treating doctor as the nominated assessor, and the worker was not successful in that regard. There are some conditions that apply to the choice of assessor under the the Impairment Assessors Accreditation Scheme. The doctor cannot be a treating doctor or a doctor who has previously reviewed the worker, unless, of course, we consent to that. So particularly a doctor who may have seen the worker a decade ago for something that was not the injury that's being assessed, you may not want to rule that assessor out. Given that there's so many assessors, unfortunately they don't all get used, of course, as we know, but there are a lot of accredited assessors on our list.
What I'd make about that is perhaps you might occasionally think it's a good idea to use the treating surgeon as the assessor, particularly those who think they're better than God and that their surgical outcomes are so fantastic no one could possibly have any ongoing impairment. Speaking of surgery, I think one or two other points that are worth making in terms of leading up to undertaking the assessment. We quite often get asked the question, well, the person's got a hip injury, they've been told they'll need a hip replacement in 20 years' time. Do we get to delay the assessment? No. Contrast that, though, with the person who wants to have their impairment assessment now, albeit that they're booked in to have or intending to have or deny but really want to have carpal tunnel surgery at some stage soon. It's almost inevitably better to ensure they have the surgery first, as it generally results in an outcome of much less impairment assessed, except for the odd extreme case. So be mindful of that one. In contrast, one, it's almost better to ensure the surgery. The other, you can't delay the process just because surgery might occur or even will occur, but not for 20 years' time. As we know, most people are advised not to have definitive replacement surgery until as late as possible, and that could be 5, 10, 15, 20 years.
The carpal tunnel scenario that Mark raises is a really important one. More recently, we've seen bilateral carpal tunnel assessments coming in at 31 and 34% before any surgery, so that's a really good example. That is absolutely going to maximise someone's entitlement, whereas if they have the release, it shouldn't be that high. So once we get our report from the accredited assessor, of course, as you know, it has to be compliant with the IAG's methodology. I appreciate, though, that each business may take a different view in terms of its compliance process, and whether you do that formally or informally is a matter for you. But you of course know that you can have the reports peer reviewed to determine if the appropriate methodology has been adopted. If there are any concerns about the doctor's assessment, you're not allowed to unilaterally make contact with the assessor and ask the assessor to revise or amend their opinion. The SAET has been quite firm in their view about this issue. It's matters such as Palios and Cordova canals, where they've indicated that it is not appropriate for us just to make that contact with the doctor and ask those questions. So the appropriate course to do so, if your worker is represented, is to make contact with the legal representative, indicate that you've got some concerns about the compliance or what the issue is, ask their consent. We often go as far as saying, we'll prepare our report request for the doctor's consideration, we'll forward that to you for any comment or anything you would like to make. You get your consent on that basis, you advise the doctor that that's the process you've undertaken, and they are happy to at least consider your report request. I won't go as far as saying happy to take your comments on board and revise the assessment, but sometimes they do. Again, sometimes even when you've gone through a formal peer review process with a different doctor, and as you know, of course, that doctor might raise some issues, you still have sometimes the accredited assessor come back and say, we disagree, or we maintain our view. So they are unfortunately difficulties that we're faced with. But it is easier to maintain your position on a non-compliant report pre-determination of the entitlements than what it is, of course, as you know, after. So if for whatever reason you make a determination and that is disputed, it is still difficult for us to say, well, it should now be nil, you threw it into dispute because it wasn't compliant. It's far better for us to issue a decision which says we're not relying on the accredited assessor's report because it is non-compliant and therefore your assessment is nil, and then go through the SAET and attempt to conciliate those issues or get the medical evidence that we need. Okay, so dealing with claims where an injury has not been accepted, we know that the matter of Lomond suggested that a request for a whole person impairment assessment is a claim for compensation in its own right. So if that injury hasn't been claimed for, the issue of compensability could be determined after the permanent impairment assessment process, Of course, we didn't like that because it does create a little bit of difficulty for us in having to go through a very expensive impairment assessment process before we can look at compensability, but we also know that the court doesn't preclude us then from challenging the compensability. If an injury has been previously accepted, that doesn't stop us from revisiting compensability for the purposes of that lump sum claim. So it's important we get on with the process, because you don't want to be trying to attempt to defend an application for expedited decision or going before the presiding member with a list of reasons as to why we can't proceed with the impairment assessment, particularly if the issue around that is compensability. I also appreciate from a practical sense, however, that sometimes you just receive a WCC with an injury listed on it at the time that someone asked for their impairment assessment process to be kick-started. So I do appreciate at the same time that your hands are somewhat tied, insofar as that might be the actual first time you've heard of a neck injury or some other body part, and that does require some investigation. At the same time, my view is always trying to indicate to the injured person, whether they're self-represented or not, to say we do still require some information around this injury to provide to the accredited and nominated assessor. Okay, so very generally, to summarise the assessment principles, as Tracey will go through some real examples with you, it's important to gather as much evidence as possible before the assessment takes place. Don't be afraid to use IMEs as part of that process. Don't just give the worker the option of 3 assessors. Send out the list. Again, I don't know what everyone's individual practices are. We know if they're represented what names are going to come back. It's a pretty safe bet. But 17.3 of the IAGs, of course, requires us to give those lists of full accredited assessors. And again, provide the assessors with instructions about the relevant assessment principles that may or may not apply. So what we say should occur in terms of a necessary or relevant deduction, what matters might be in dispute, generally like to put them in 2 separate tables: accepted injuries, rejected injuries, because again, up until recently, when the combination issues were in contention, sometimes you didn't know what the date of injury was for those consequential injury claims. And again, please obtain those lump sum checks certainly before we issue a determination in terms of any entitlements, because again, really difficult for us to go back and try and make a 56.6 deduction if we haven't determined that as such. Again, the big one, I say it again, no unilateral communications with assessors, even if they are assessors that we're very friendly with and deal with a lot and who respond to our emails expeditiously. Always get consent. You don't know when the other side is going to take that point. Check for compliance issues, not the easiest thing to do, but very generally, everyone's got that gut feeling when you see, for example, a finger assessment come in at 9%, as I did not long ago, when the overall assessment to the wrist was 5%, but the right index finger was 9%. That had my spidey senses tingling a little bit, and we went off and sought some clarification, and it was in fact an error. So they're not always clear cut, is the message there. And again, if wherever possible, if we can document the hours work factor at the start of the claim when determining the average weekly earnings rate, that again is very beneficial. It is a nuisance when the only thing that's being challenged from your Section 56 entitlement decision is the hours work factor. It shouldn't be 0.6, it should be 0.7, or the worker increased her hours a week before the injury, etc. All of those things. So if that is something that's stipulated at the very beginning of the claim, then you can have that argument at the very beginning, as opposed to what sometimes some years later, depending again on what payroll records are available. I've gone too far, I'm sorry about that. There we go. Oops. There we go. Just lastly, if we look at Section 56A for seriously injured workers, as you know, they can now elect to receive a payment for economic loss. They must receive professional advice, financial advice and medical advice, but no entitlements apply for psychiatric impairment, noise-induced hearing loss, transitional claimants or workers with injuries that were sustained pre-1 July 15, or workers who have redeemed their entitlement to weekly payments. If a payment is received, no further or other entitlement to weekly payments or rehab and return to work services are to be provided. If the worker has an impairment of 50% whole person impairment or greater and they elect to receive an economic loss payment, then as you're aware, we're required to have the election referred to the SAET for approval by a presidential member. They happen very quickly in my experience, so it doesn't tend to hold up the process too much. The lump sum entitlement is the same as the 56 entitlement calculation, prescribed sum versus your age, multiplied by your age factor multiplied by the hours work factor. The prescribed sum, as you may or may not be aware, caps out at 34%. So for 2023, it's $539,281. The transitional provisions generally apply for workers who were assessed as seriously injured on a final basis prior to the 17th of October 2022. There are some exceptions to that, but they are not regular exceptions. The calculation amendments, the age factor is to be based on the worker's age at the date of the election and not the relevant date. So the age factor is reduced. The total payment under 56 cannot exceed the prescribed sum applicable for 29% whole person impairment. And the payment is to be deducted by weekly payments made to the worker on or after the 17th of October 2022, to the date of the election, rather than any payments after 104 weeks. So they're just the important things to remember when you're calculating that 56A payment. And of course, we're always happy to have a look at that for you and just to make sure that the weekly payments are being deducted for the accurate relevant period. I think that's it from me.
Thank you, Chrissy. That was terrific and a good overarching assessment and view of go to woe. One or two things I was thinking of as you were giving the presentation, and it comes back to that issue about whether you're setting the worker off for a range of injuries that are all accepted as compensable or some that may not be, and it's always worth indicating that to the doctor, what is being considered as compensable and what is not. Now, the doctors, when they're doing their impairment assessments, don't actually indulge in the causation issue, so in a sense there's no point asking them about that, but it's also always useful to at least let them know what's going on. That's where your independent medical assessments might come in later on or at that same time as to whether what's being assessed is compensable. One other matter to bear in mind, and it's only happened very recently in another matter where the worker turned up at the assessor and the assessor was to consider injuries A and B, and during the assessment the worker also told the doctor about injuries C and D. And the doctor proceeded to make assessments in that regard despite it not being covered by the referral and produced a report. Now, in that circumstance, you are perfectly entitled to go back to the doctor, in my view, and say, sorry, you can't do that. Under the guidelines, you should have stopped the assessment, raised these issues with us, because quite clearly the compensating authority would not have been on notice about any of it potentially, and of course to then go and obtain and present, well, whatever evidence there might be, even if they consider that there was some remote prospect of compensability there. So the whole lesson is don't allow this sort of thing to go forward in any way, shape or form, and the doctor shouldn't have proceeded, but there has been cases where that has occurred. So I don't know if it'll be a thin end of the wedge thing, but certainly something to be alive to. So with that final comment, I think we'll now zoom over to Tracey, who hopefully will unmute herself, take control of the computer. And sorry, there are some questions.
Just two questions from the Zoom, Chrissy. Would you recommend a peer review or return to work compliance review on all PIA reports?
Probably not all. Well, I guess as a general rule, not all. I think if there is, for the most part, everyone listening and everyone in the room has seen enough of these now to really identify the big glaring issues or errors, have seen enough of other same body part assessments to know whether deductions and other things can be made. or whether ultimately you didn't have, for example, the radiological imaging to allow particular deductions to be made, etc., to accept whether or not something is compliant or not. I think if you are talking about a minor difference between a deduction or assessments being combined, which make the difference between someone being seriously injured or otherwise, that is probably a good one to check compliance issues on. But it would be a very expensive process if you were checking compliance on every single report received.
And to take that one further, you can do your own ad hoc peer review, even at the most superficial level. Just double check that the tables that the doctors use in their reports are accurate. I had an assessment for, off the top of my head, knee, and the doctor used the table for ankle. So straight up, just complete stuff up.
What is the correct way to work out hours worked factor? Is it hours worked at the time of the injury or an average 12 months prior and taking out sick leave and annual leave?
That's a good question. When you're doing your average weekly earnings calculation, if you are able to use a 12-month history, that's very much the starting point. We do know that, unfortunately, that's not the perfect example for all injured workers. So where you do have to use a lesser period, then it will be that lesser period that still ultimately determines the average of the hours worked, which is going to give you the average of the average weekly earnings, if you like. As to whether you should take, was it sick leave and annual leave out at that time? I don't think so, no. No, we can't do that, can we, from an industrial perspective? No, they have to be included, those periods of time.
If the worker's income has ceased and they've requested a PIA, we have asked the worker to attend an IME. Can they refuse the IME?
Yes, they can refuse the IME, but at the same time, then we can refuse to proceed with the impairment assessment process. If we feel as though we don't have the adequate documentation to provide to the doctor to make the assessment, then you can stand quite firm on those grounds. And ultimately, if that means that you're forced to issue a decision so that there is something that they can dispute, then you say that you don't have an entitlement to the process, and obviously state the grounds so it's quite clear as to why it is that we need this information. Because I do appreciate that there are certain practitioners on the other side or claimants think that we are attempting to undertake a fishing expedition at that point in time. It's really not. It's just making sure that the doctor has enough material to be able to do the assessment, because it's an expensive process. You don't want them coming back and saying, I can't do it because X, Y, and Z documents are missing, or I really need this. Sometimes that happens, but you don't see it often in our experience from a dispute, on the dispute side of things.
You all hear me? I take that as a yes. Mark, I'll have to get somebody to change the slides, and I'll just say next slide when I get to it. And apologies in advance. I'll endeavour not to have a coughing or a sneezing fit in the middle of the session. So, yeah, here goes. And let's fingers crossed that doesn't happen. So I'm going to have a look at a more practical side of things, which is an actual case that I'm actually dealing with at the moment, because I thought it was useful because it demonstrates a number of the practical problems that Chrissy has identified in her session with from the more legal basis. So our case study involves a lady who's 44 at the date of injury. She's involved in a compensable motor vehicle accident, suffers whiplash injuries to her neck, stiff shoulders, both hips, right ankle, right knee, and a large bruise to her breast. So typical type injuries from a motor vehicle accident. Next slide, Mark. She doesn't actually lose a lot of time from work, but because of some issues with her employment, she moves on to other employment. A couple of years after the accident, she is seeking to have her permanent impairment assessed. She's not represented at that point in time. It was quite clear that she had had prior neck and shoulder problems in the past, possibly as a result of previous motor vehicle accidents. But there wasn't a lot of information in the reports that have been obtained for the work injury as to what the extent of those problems were. And it really raised an issue of what might be the deductions that should be made by an assessor and how much information we needed to gather to try and put the best case forward to the assessor to ensure, hopefully, and I say hopefully, that some deductions were actually made. Next slide, Mark. Sorry, we seem to have moved along too far. Sorry. As I said, there wasn't a lot of information about these earlier injuries. So the advice I gave the client was, well, we really need to go back and do some digging and get information about these earlier injuries that we could include in the report request, because if you don't provide anything, you're not going to get anything from the doctor, because there'll be no basis for it. The difficulty that I'm sure you all experience when you start trying to get this information is that you are very much reliant upon cooperation by the worker and by the doctors. And there are some doctors that will just refuse to provide medical notes, even if the worker authorises them. They won't provide them unless there's a summons. But of course, you're not in dispute, so you don't have the ability to access documents by way of a summons issued by the tribunal. So you are, to a large extent, dependent upon people being cooperative. And now, if things become quite difficult, that might result in you at a later date trying to get the notes in reverse, but always best if you can try and get them before you send the report request off. If all else fails, there is the Section 183 process with Return to Work SA, where you can apply for an authority to get the notes via an assessor. But in my experience, Return to Work SA is quite reluctant to issue those authorities. So it is a bit of a bind as to how you go about it. Fortunately, in our case, we were able to collate a reasonable amount of information. The worker was quite cooperative and gave quite a bit of information about the prior problems and where she'd been treated. So that was very helpful. Had she not been cooperative, we probably would have had to do what Chrissy suggested, which is simply decline to proceed with the process because we couldn't get enough information. But this worker was very good, and she agreed to, she basically said, these are the injuries I've had and this is where I was treated. So we were able to get notes from Flinders Medical Centre. We're able to get diagnostic imaging dating back to 2012. So that's 10 years before the request for the PIA was being made. She indicated she had a motor vehicle accident in 2005. She'd seen a physiotherapist, but she couldn't remember who it was. She'd seen a GP in Rosewater, but again, couldn't remember that clinic or who it was. But generally, she'd mainly been treated at the one clinic for a very long period of time, and that clinic had merged with another clinic and was basically the same clinic. So there was a reasonable amount of medical evidence available. She also had a lower back injury. That was not a work injury and was separate to neck and shoulder problems. So we did reasonably well in getting a whole heap of early medical information and put together the draft PIA report request. And in the report request, we made reference to the previous whiplash injury to her neck in 2005. We noted she'd been seen at the Western Hospital in 2012, where there was an ultrasound of both shoulders taken. Her GP notes had consultation treatment notes for both lower back and neck pain over a number of years. There was also reference to bilateral shoulder problems. She'd had chiropractic treatment both for her lower back and for her neck. She'd had an injection in 2017 into the right C3-4 level and a nerve root injection for neck pain in August 2017. So based on that, you would assume that there was a reasonable basis for a deduction to be made in terms of her current PIA assessment. She nominated Dr. Dionisi, and I'm sure everyone will know that he is probably one of the limited number of assessors that tend to get nominated in this jurisdiction. There seems to be fairly regularly the same handful of doctors nominated, despite the fact that there are many other accredited assessors. It's what we deal with. He provided his assessment and reviewed all of the documents provided, and he noted the various earlier problems for which she had received treatment. He gave her an assessment of DRE category 2 for the cervical spine. That gets an automatic 5% assessment, and also gave her 3% for impairment of activity of daily living. So she had a total 8% for her neck. And then he used the range of motion method of assessment for the right and left shoulders. That's the appropriate method to adopt. Basically gave her 6% for each shoulder. Next slide, Mark. He didn't find any assessment or any impairment of the right knee or ankle, but the worker herself had already said that those conditions had resolved. The problem that we experienced is that Dr. Dionisi refused to make any deductions for either the neck or the shoulders in terms of all these prior problems, because he basically stated that the 2012 problems for the shoulders were very mild, and he referred to them, quote, probably resolving, unquote, whatever that means. Gave no indication as to why he thought that was the case, whether the worker told him that. He just said, I think these had probably resolved. And in respect to the neck, he thought that although she had pain in 2016, these symptoms had ceased around 2017. And he again presumed that her neck problems had resolved. And again, the basis of that presumption was unclear. So he gave no deduction at all, and basically gave her a 19% whole person impairment when you combined the 8% and the two lots of 6%. So that was pretty disappointing, to say the least. Can I have the next slide, Mark? We should be up to Dr. Cross peer review. Thank you. So Dr. Cross did a peer review for us, and he made a number of quite obvious criticisms of the report. He thought that the 3% for impairment of activity of daily living was not clearly explained, and he thought there was possibly some overlap between the impairments in terms of the neck and the impairments in terms of the shoulder. He noted the presumptions about the previous shoulder and neck problems resolving, and there being little rationale for that. And he thought that overall, the failure to make any deduction at all was inconsistent with the guides, and he was quite critical about the report and said it was not compliant. So, can I have the next slide? Oh, actually, we can move further along, Mark, so we can be to the one that says non-compliant report. So we clearly have a non-compliant report, and then have to make decisions as to what happens now. Now, as Chrissy alluded to, we couldn't have any unilateral communications with Dr. Dionisi, so we couldn't send him the report. The worker was still unrepresented at that point in time, so it was my advice that the best option was to issue a determination refusing to rely upon the decision, and that the worker had a nil entitlement. The worker would no doubt then go and get some legal advice, and we would get an application for review. We would be at the tribunal, and once the worker was represented, we'd be in a position to then go back to Dr. Dionisi and put Dr. Cross's views to him for comment. And that's basically what happened. Can I have the next slide, please? So as part of the dispute process, it was agreed that we would write back to Dr. Dionisi, and I put to him 4 matters, which are outlined on the slide. The rationale for presuming that the shoulder and cervical spine symptoms, the previous ones, had resolved, and what was the medical basis for that assumption. Why no deduction for pre-existing impairment was made. What ADLs had in fact been impacted by the impairment of the cervical spine as compared to the right and left shoulders, and did the peer review comments from Dr. Cross alter his assessment in any way. So when we got the response, it basically provided some more history about the ADL issue and how Dr. Dionisi came to his view about what was causing an impairment in terms of the neck as compared to the shoulders. So we got a little bit more information about that. He did not in any way respond to my query about why there was no deduction for pre-existing impairment. And he basically said, Dr. Cross is wrong, and I'm not changing my opinion. So that didn't take the matter much further. So we attempted to conciliate. Can I have the next slide, please? We attempted to conciliate the issue at the conciliation phase. We had some negotiations. Unfortunately, we weren't able to get to an agreement, but there was some attempts to do so. And if we'd been able to agree a reduced assessment, our conciliator would have signed off on orders to do an assessment less than the 19%. But unfortunately, we weren't able to agree on what the reduction should be. And the matter then got referred on to hearing and determination. As part of that process, we have also then gotten some further medical evidence. Dr. Champion has reviewed the matters on the papers and gave very similar comments to those given by Dr. Cross in terms of the issues involving Dr. Dionisi's opinion. Then, somewhat surprisingly, the workers' lawyers put forward a suggestion that we do an indicative PIA with an assessor with which both parties would be happy. And that seemed like a really good idea, because I thought, oh, well, we get someone we both agree on, we get an assessment that hopefully we're both happy with, and then we'll be able to have some further negotiations, rather than the only other option being to proceed to trial, have a lengthy trial, and then a referral to an IMA. So that's the process that we then agreed on. Now, we couldn't have done that unless there was agreement. That's not in any way part of the way the guides and the tribunal rules work. But because we were prepared to do it by agreement, we were able, that actually happened. So we had the assessment by the indicative assessor. Unfortunately, that put a spanner in the works, because the indicative PIA assessor actually put the worker in a higher DRE category for the neck. So rather than being 5%, she was 15%. So I was like, oh, well, this isn't looking good. And the basis of his opinion was that there was reference to radiculopathy, which would put the worker in that higher category. But there's no actual evidence in any report that's ever referred to as suffering from radiculopathy. So we've taken a turn that wasn't expected. The assessor did, however, do a deduction for the prior neck problems and said that they were at least 7% deduction should have been made. So that brought the assessment down in terms of the neck. He also did a slightly reduced impairment of ADLs of 2% as opposed to 3%, but the assessments for the shoulders were similar, and there was no deduction made for the prior problems. So in the end, what we got from the indicative assessor was a combined assessment of 18%. So we've basically reduced by 1%. So we haven't really gotten to where we thought we would be getting. And can I have the next slide, which should be what options? Yeah, so this demonstrates the problem you have with different assessors. You cannot be in any way assured of what the outcome's going to be, because we took a complete left turn with the higher DRE 3 category for the neck. We had some progress on the deductions, but not much else. So it does show the problems of different assessors just take very different views, and it's a bit of a lottery sometimes with what you are doing. So we haven't actually finished this case. So this case is still at hearing and determination. And if we don't, can I have the next slide? We can still try and conciliate. If that doesn't resolve the matter, we can go to trial. That's the only other option. Somebody's either got to concede or we've got to go to trial. And it will then be open for the trial judge to determine whether Dr. Dionisi's opinion is compliant or not. And if he finds it's not compliant, then the trial judge must refer the matter to an independent medical advisor. So we haven't got there just yet, but there have been some cases where that has now happened. And they raise the problem then of the IMA assessment not being reliable. So this case of Staker that I've referred to is a case that Judge Kelly's been dealing with. The Staker case relates to a person with a psychiatric injury, and the person was trying to be assessed as seriously injured. So they had to go through the whole person impairment assessment process to get the decision as to whether or not they were seriously injured. Dr. Begg undertook the original assessment and assessed them at 25% whole person impairment with a 2% deduction for non-compensable disorders. It was eventually determined that Dr. Begg's assessment was incorrect. He had made some errors, particularly in terms of one category of the GEPIC assessment. We don't see a lot of GEPIC assessments, but when you look at the GEPIC, there's like 5 categories of functioning that they have to assess, and one of those functions is thinking, and he had incorrectly assessed that category, which affected the overall assessment. So ultimately, Judge Kelly found that Dr. Begg got it wrong, and therefore she referred the worker to an IMA. The IMA was Associate Professor Khalid. Unfortunately, when they got the report back from Associate Professor Khalid, it was noted that that report was also non-compliant, and a number of issues had been overlooked and were not properly expanded upon. And so they've had further argument about what happens now. And the recent case that Judge Kelly handed down, she found that Professor Khalid's report was not admissible, and that's what she had to do. And she was proposing to actually write back to the doctor herself and circulate a draft report request to try and fix the errors. The only other option would be a referral to a second IMA. So we're obviously getting into territories that is very, very complicated. And again, illustrating this issue of once you're in this process, it can be a real lottery as to what the outcome will be. And the judge is unable to simply substitute their own findings for that of the IMA, and that is because of the way the Act is worded. And in that the assessment, the PIA assessment, has to be by an accredited assessor, and a judge is not an accredited assessor. So they are relying upon the accredited assessors getting it right. And if they don't get it right, they keep on having to try. So it'll be interesting to see what happens with that matter and whether there's any further hearings on it, or whether at some stage they just try and get it sorted out by agreement. Can I have the next slide? Should be headed credibility issues. Now, the other issue in terms of PIA assessments is if you get the report back and you disagree with the factual basis of the assessment. Now, there may be reasons why you disagree with it. You've got other evidence that suggests what the worker told the doctor was wrong, or the worker presented in a way that you say is inaccurate and not actually reflective of their impairment, and that has negatively impacted the assessment. What do you do about it? So the case of Parry that Judge Crawley dealt with is an example of that. The worker had a knee replacement and had been assessed by the PIA assessor at 31%, which I think at the time meant he was seriously injured. There was a lot of medical evidence that suggested that the worker, in fact, had quite a good result from his knee replacement surgery, and he told his treating doctors that things were going really well. He presented in a way that suggested the complete opposite, and clearly the assessor, who was, I believe, Dr. Tran, found that he had had a poor outcome, which got him into the automatic 30%, and then I assume 1% for scarring. Having a look at the case, it doesn't appear that they actually had surveillance. They were just relying upon the way the worker presented to his treating doctors and possibly at work, and the way he was presenting to the assessor, and a lot of cross-examination of the worker at trial. And the judge ultimately found the worker's evidence was unreliable and that there was significant discrepancies between the history to the treating doctors and that given to the assessor. He did not criticise Dr. Tran's assessment. I think he was blaming the worker for the way he presented, and as a result found that there was no option but to refer the worker to an IMA to have an assessment. Can I have the next slide, please? So that raises the other issue of surveillance. Now, what if the issue that you have with the report is that you have surveillance where the worker presents in a completely different way to the way they have presented to the assessor, and you believe that the assessment is based on an inaccurate history, and that's negatively impacted on the results. There has been one case where there was an issue about surveillance, and this is the case of, I think it's pronounced Metedjic, apologies if that's not right, and Department of Treasury and Finance. Unfortunately, it proceeded before Deputy President Litschke, who clearly was not in any way impressed by the surveillance that had been taken over a long period of time. And the compensating authority was endeavouring to have the matter referred to an IMA on the basis that they were asserting that the assessment provided was not compliant and couldn't be relied upon because there were basic factual errors that affected the outcome, and that the judge should basically find that the report could not be relied upon, refer the worker to an IMA, and also provide to the IMA assessor the surveillance that had been taken over a lengthy period of time. Unfortunately, that fell on deaf ears. Judge Litschke wasn't persuaded by the surveillance or by the cross-examination of the worker, and he wasn't prepared to send the surveillance to the IMA in any event. So that unfortunately failed in that case. Can I have the next slide, please? But that issue is still one I think that potentially could be raised on an appropriate case. But the issue of showing the surveillance to a PIA assessor is a very tricky one and needs to be dealt with quite carefully, and decisions made about when and how you show surveillance to an assessor, or do you show it? Do you just simply wait for the report to come in and then say, well, we don't accept the factual basis of this report, therefore we're not going to rely upon it, clearly issue a determination rejecting any entitlement, and then obviously in dispute, and then you have to make a decision as to when and how you're going to show the surveillance, and are you going to keep it up your sleeve for cross-examination and hope that you get a better outcome than what they got in the Metedjic matter. And that's always going to depend upon what is in the surveillance as compared to what the worker asserts. And because the value of surveillance always lies in what the worker says they can or cannot do. So that issue is something that really needs to be dealt with very carefully, and sometimes almost strategic decisions made as to when and how you're going to deal with it if you do have surveillance that you believe shows that the worker is not presenting accurately to the PIA assessor. So I think that issue is still up to be dealt with in the right case, but obviously for whatever reason in the case that Judge Litchfield dealt with, he wasn't comfortable with the suggestion of sending the surveillance to the IMA, but it might be something that happens in the right case. So my summary from all of this is preparation is always a key, but preparation will not guarantee the outcome that you want. Having said that, if you don't provide all of the relevant information and you don't do the prep work that you need to do, you're not going to have any basis to challenge the assessor after the event. I mean, the Supreme Court has made it clear in the case of Psevdos that the doctors, should be making deductions when there is evidence available that shows that prior impairment exists, even if they can't strictly follow the guides. And I've seen a number of the doctors say, well, I can't make a deduction because it doesn't fall within how I'm supposed to do it under the guides. And if I can't do it under the guides, I'm not doing it at all. Psevdos said, well, that's not the test. The Act requires deduction and they can use clinical judgment to make deductions. The problem is, and I think Chrissy alluded to this as well, is that a number of doctors are reluctant to do so, but we should be pushing this issue all the time, because otherwise the doctors will continue to do it and you won't, you've got clear evidence of prior impairments and no deduction being made. And the lady that I've done the case study on, 19% is a very high assessment, gets a very significant sum of money, both in terms of 58 and 56 entitlements. So it is worthwhile challenging. So that's pretty much it from me. Sorry about my voice, it's worse than normal. But if there's any questions, I'm happy to answer them.
We've got a question from the Zoom.
Mm-hmm.
You can probably read it in the chat.
Read it to me anyway.
If the available medical information and history does not match how the worker presents to the assessor, what is the obligation of the assessor? Are they required to take what the worker says at face value?
Well, I think most assessors take the worker at face value anyway. I mean, I guess they have to exercise their clinical and medical judgment as to the history provided, and if there is other information that seems to contradict that. But I mean, I think there's a tendency for most assessors to simply take the worker and what the worker tells them, and it's up to us to then look at whether or not information is actually accurate. I personally haven't seen a lot of forensic investigation by assessors into matters of fact or review of the medical evidence as compared to what the worker tells them. I haven't seen a lot of stuff where reports where I can think, oh well, yeah, that doctor really got down into the nitty-gritty and reviewed the reports and noted inconsistencies. I think they just, and you see them say, well, it's my assessment on the day and that's what I'm required to do. So yeah, I don't think there's a lot of real forensic investigation.
Before we take any questions from the floor, just to add a few things to those comments, yeah, it is all about how the worker presents on the day, as at least in the eyes of the assessor, but talking about things like independent evidence, particularly in range of motion cases. If you think or see that the worker has bunged it on or suspect that the worker has because of exaggerated in past assessments, getting hold of things like the physiotherapy treatment records, which quite often have range of motion findings in them that are contemporaneous with the review, is a useful piece of information. It might supplement your video evidence that shows the worker at the assessment, getting the arm up to barely halfway past the hip, whereas the range of motion at the physio and the video evidence shows something completely different. So be mindful of that sort of information that you can seek out. In terms of medical records, be careful in a sense what you do provide to doctors, because if you decide to provide them with the entire Flinders Medical Centre records and Dr Smith's 15 years of medical notes and x-ray reports and everything else, you may well get charged for it. And it runs to, in one case, I think, tens of thousands of dollars. So be mindful that you provide only what's probative to the issue. If it's and remembering that really they're not there to explore causation, but things like the consistency of the complaint or of the recovery from the operation and that history when it comes to issues about deduction or whatever, that can be important. Again, if there's references to range of motion in the GP's records, obviously very important, that sort of thing as well. Just be mindful that there's the impairment assessment guidelines as to which we are now currently using are under review, a very long-running review. It should have been finished this year. It's running well into next year, but we will have some new guidelines out at some stage in the new year. And before I wind up, from our perspective, please, those that are here, stay for a drink and a nibble, and everyone online or in person will hopefully get a quick survey to fill out when we are finished. You'll probably get that in your inbox tomorrow morning. But just quickly then, throwing it open to anyone else. Cos, down the back, you had a question. I'll just, Tilly will run the microphone up.
Matter, Tracey. When you're at the conciliation, what did the other side compromise to? How low were they prepared to go at conciliation?
Oh, I don't think I can say that actually, but I mean they were prepared to compromise a little. Yeah, I mean, and look, we were arguing quite technical issues about the ADLs compared to the shoulders and the neck, and I think our biggest issue was the deduction one, like, how much deduction should have been made. And that's the difficulty when they make no deduction. It's like, well, we want X and they want Y, or they're prepared to maybe concede on something. But it's very difficult when you've only got, and it's part of the problem of the one assessor is that, until you get, I mean, at least now, but it's only happened after we've been up at hearing and determination, we've got some options now in terms of deduction, because we've got, Dr. Champion having given a view, and we've had the indicative PIA assessor give a view. So we've kind of now got a bit more of a basis for it. But at the time we didn't, because we basically had Dr. Dionisi and his response, where he didn't even give us a response. So it wasn't particularly helpful.
Although you can get Dr. Tran give you a response that's can sometimes quite extraordinary in its content.
Responses from Dr. Tran, to the point that apparently I was named in a Facebook group that he'd set up.
All right, well, that's brought us to just after 5 o'clock. Unless there are any other questions from the floor or online, we will wind it up. I will say a great thank you to Chrissy and to Tracey for their efforts in putting the paper together. I know they put a lot of work into it. Thank you for everyone for attending in person or online and your attention. Wishing you all from us a very Merry Christmas, Happy New Year. Make it a safe one. Thank you for your support for us this year, and we look forward to working with you in the new year. Thank you very much, everyone.